Folks, we are about to wrap up what we would, I guess, arguably call the first half of the course. Although half is kind of, not necessarily accurate because even though it's like the first half of the units, these do have a tendency to take a little bit longer to get through. Just because a lot of the concepts are new to you, and there are some complex concepts that get into the mix, like specifically these last four units, right? Agency contracts, basic contract law, and now sales contracts specifically. And so while there is still technically like 12 units left to go after this, some of them are like we spend maybe 10 minutes on said unit. So it does go a lot faster, as I've been saying, which is both good and bad simultaneously, I suppose, depending on how you look at it. So we wrapped up basic contract law last night. And remember I told you basic contract law is a, national and state concept, right? How contracts work in general, what contracts can be, all of the things within. And so tonight we're moving into sales contracts. More specifically, we're going to focus on North Carolina sales contracts. And so I told you the vast majority of this chapter, 90% of it is state specific and pretty testable state specific. For whatever reason, I've heard incorporating more standard form 2T questions than they ever have historically. And I have mixed feelings about that, but it is what it is. And we just got to prepare you no matter which way you slice it. So let's get into it, folks. Let's just dive right in. All right. We've got to talk about the way that contracts kind of work. We've already talked about how they move from an offer to a contract, and so that'll make a resurgence in this section. And then, of course, we've got to talk about some of the laws and rules that are very specific in how this section kind of works. First and foremost, let me talk about what we do as real estate brokers. Folks, I'm going to show you a contract here in a minute, and I kind of alluded to it yesterday, and I've been dropping the name of it. And what you'll realize is it is 17 pages of contract, and there are a lot of blanks on the contract. And really and truthfully, that's what we do as real estate brokers. We are glorified blank filler inners. That's what we are. We do not have the legal authority to draft contracts, okay? We cannot put in special language. We are not attorneys. And so it is very specific in North Carolina that we would be in trouble for the unauthorized practice of law, meaning giving legal advice when we shouldn't, interpreting legal documents when we shouldn't, drafting legal documents when we shouldn't. Now understand, legal is doing these things for other people. And so if I had a client come up to me and they said, Seth, I want you to draft up a contingency to go in the contract. I can't do that because that would be drafting a legal document for somebody else. That's the practice of law. And as a non-attorney, I'm not allowed to do that. And so we have different addenda. Remember, that's the plural of the word addendum. These add-ons that we can put into the contract that could make it a little more encompassing, right? It could include certain information that may not be in the standard form that we may utilize. And then, of course, if there is special things that we want in the contract and we don't have a standardized form for it, what we do, and this will almost always be the answer for this type of question, listen very carefully, when there's special language that needs to get added into a contract and there is not a form for it, the answer on the test is almost always going to be CYA. Contact your attorney. Okay? If we need to add special language, if our client needs something unique added, if it's, anything like that, the answer will almost always be contact an attorney. All right? If we need interpretations on certain things, that's going to be an attorney. There's certain things that we just can't do. We give them advice, we help them negotiate, we do a lot of things, but we cannot give legal advice, can't draft legal instruments, can't do any of that. Now, I will tell you that, and it's going to come up in a slide, but just so I can go ahead and make this clarification, because you got to be very careful about these test questions. Folks, I told you, drafting legal documents on behalf of others would be the practice of law. What that means is, anybody can draft a legal document for themselves. It just may not be satisfactory for the courts. And so if you had a client that wanted to put a contingency in their contract, they could draft it up themselves. My client could type up on a document contingency and all the details, and I could add it into a standard contract, and I would call it a party drafted contingency addendum. It is okay for my client to draft something for themselves. Everybody with me there? Arguably, if they wanted to, they could write their own contract in its entirety. There's nothing stopping them from doing that. So if they said, well, hey, listen, I just want to type up my own sales contract to submit an offer. Can I submit that on behalf of them? Yeah. They wrote it up. I didn't give them legal advice. There's no unauthorized practice of law. Is it a good idea? No. But could we do it? Yes. Now, I'm going to explain something here because this is another thing that a lot of students get caught up on, okay? We are going to talk about the standard Form 2T in North Carolina. It is a very commonly utilized contract, but I want you to listen very carefully. It is not the only contract in North Carolina, and it is not a requirement to use this contract. It is just one that exists that happens to fit within the confines of the sales contract law / rule that we can use. And so I showed you some of this early on in the course, but I'm going to show it to you again. If you look at the license law and commission rule book, and we've been talking about a lot of things from it throughout the course, and we will continue to do so, there is something called the sales contract rule. It is right here, L112, offers and sales contracts. And when you look at this rule, it says a broker acting as an agent in a real estate transaction shall not use a pre-printed offer or sales contract form unless the form describes or specifically requires the entry of the following information. And there are 19 required provisions that have to be in this form that we would potentially give our clients, including the names of the parties, how we're going to handle breach, earnest money, what portion is going to be a loan. You're not going to need to memorize those 19 things, but that's all this rule states. We can give them any pre-printed sales contract so long as it contains those 19 required provisions. The other big thing that it says is that it cannot contain 2 prohibited provisions. And these prohibited provisions like to show up on the test. It says, a broker acting as an agent in a real estate transaction shall not use a pre-printed offer or sales contract form containing 1, any provision concerning the payment of a commission or compensation, including the forfeiture of earnest money to any broker or firm. So we can't talk about brokerage commissions on the sales contract in any way, shape, and form. Folks, where do we talk about brokerage commissions? Agency agreements. There you go. The agency contracts. So the other thing that is prohibited from any pre-printed sales contract that we recommend using is any provision that attempts to disclaim the liability of a broker for his or her representations in connection with the transaction. In other words, no disclaimer of liability. Those 2 things are prohibited in a pre-printed sales contract that we may utilize as brokers. It cannot contain any discussion of brokerage compensation, and it cannot contain any disclaimer of liability. Now, as long as we have a pre-printed contract that's been drafted by an attorney or somebody like that, and it meets those criteria, right, the 19 required things, and doesn't contain the 2 prohibited, we can use any contract. So I'll say it again, we are going to focus on the standard Form 2T, but is that the only contract that can be used in North Carolina? Shake your head, say no. There you go. No, 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 no. So the standard Form 2T is one that is drafted by NC Realtors in conjunction with the North Carolina Bar Association, the attorneys. And it is done for realtor members to use. And as such, it is branded for realtor use only. If you're not a realtor, you're not allowed to use that form. Now, there are similar versions of the form that are branded just for the Bar Association that you can get as a non-realtor if you reach out to an attorney and get it from them. Now, here's a clarification, right? I'm telling you that North Carolina Association of Realtors writes the contracts, not the North Carolina Real Estate Commission, which is the licensing authority, which is the one who, sanctions this class, so on and so forth. There are actually only 3 documents that are drafted by the Real Estate Commission that we use day in and day out and that we've already talked about in this course. What are they? There you go, Bridge. There's one. The Working with Real Estate Agents Disclosure. I'll give you a hint. The other 2 have the word disclosure in them as well. It's not the lead-based paint one, although it's a good guess. Nope. All the agency agreements are NC Realtors as well. You got it out of order there, Bree, but we'll give it to you. The RPODs and the MOG. The RPODs and the MOG. Okay, the Residential Property and Owners Association Disclosure Statement and the Mineral Oil and Gas Rights Disclosure Statement. Those 3 are drafted by the North Carolina Real Estate Commission, and we use those day in and day out. But all the other standardized forms that we'll talk about throughout this class, really and truthfully, NC Realtors, right? The exclusive right to sell listing agreement, NC Realtors. The buyer agency agreements, the offer to purchase and contract, all the standard addenda, all of those are NC Realtors, not the Real Estate Commission. Now, let me just make sure you're with me here, and because I kind of repeat it multiple times because I told you it likes to manifest on the test. What were the 2 things that I just said could not be on a pre-printed sales contract that we utilize as brokers in North Carolina? Yep, no discussion of brokerage compensation and
disclaimer of liability.
No disclaimer of liability. There you go. Those are not allowed. Okay, not allowed. So when we're dealing with the contract, okay, I told you we can't draft anything. We can't change language. To do so would be the unauthorized practice of law, and we can't do that. If you didn't notice, there was like a no drafting of legal instruments rule right above the rule that we just looked at, and we'll go back to it in a minute. But I told you parties to the contract can. Parties to the contract can. So your client could draft their own contract. Your client could draft their own contingency. Your client could draft any kind of addenda. I mean, they could do whatever they wanted, really, and we could add it to the contract. There's nothing prohibiting that. And so let me show you where it specifically states this back in the license laws and commission rules. If you keep reading into this, it said, the provisions of this rule shall apply only to pre-printed offer and sales contract forms which a broker acting as an agent in a real estate transaction proposes for use by the buyer and seller. Nothing contained in this rule shall be construed to prohibit the buyer and seller in a real estate transaction from altering, amending, or deleting any provision in a form, offer to purchase, or contract, nor shall this rule be construed to limit the rights of the buyer and seller to draft their own offers or contracts or to have the same drafted by an attorney at law. So there's that clarification. So you're going to be very careful on the test. If you have a test question that says the broker drafted a contingency and then it asks you if that's okay, no. If it says the buyer drafted a contingency and the broker added it into the contract, is that okay? Yes. Bill says, may they strike through language on the standard contract? Yes, they can. We can't, but they could. Now, that being said, folks, parties to the contract can do it because it's not for others, right? Which means it's not the practice of law. Lisette says, are we allowed to tell them they can? Yeah, you can let them know that. that, since it's for them, I mean, we shouldn't be telling them what to add, what to delete, or anything like that, because then we're basically just using them as a puppet, right? And that's still going to get us in trouble. If we're like, no, delete this and add in this language, that's going to get us in trouble. But I want you to think about this. A party to the contract can change it, modify it, do whatever. And so I told you we can't change the contract for our clients. That would be a no-go. But is there a contract that we've discussed that you think that we as licensees potentially could modify or add or take away language on? There you go, Gerald. Agency agreements. Why?
It's we would be party.
There you go. We are a party to the agency agreements. You see the difference there. In a sales contract, the parties are the buyer and the seller, and they can make modifications because they're the parties. In an agency agreement, the parties are the seller and the firm, or the buyer and the firm, and we are a sub-agent, right? We're a general agent of the firm, so we would be allowed to make modifications to agency agreements. Let me also give you the bonus question here, just to see how froggy you are feeling. Can you think of a time that we as real estate brokers may be able to modify language in a sales contract? There you go, Brad. I could see your eyes light up as soon as I said it, and I was just waiting on you to type it. If we are a party to it, folks, if I am buying my own house and representing myself as my own broker, I'm a party to that sales contract. Could I modify the language then? Yeah. It's not for others. It'd be for me. So that would not be the unauthorized practice of law. Does that make sense for everybody? There you go. Now, I'm not going to beat it into you this much. This is just basically the same thing that I already asked you, what two things cannot be in a pre-printed sales contract. What you got, Brooks?
On the last slide, it says, may alter, delete, amend provision in a standardized contract. What is North Carolina's definition of a standardized contract? Or is that a who the hell knows kind of thing?
Well, and the one that we're going to look at, the 2T, is a standardized contract. And so it's just like a contract that's generally accepted for use in a certain transaction. And so I told you, the Bar Association has some standardized forms for certain things. The Association of Realtors has some standardized forms for certain things. Both of those would be examples. But it's not saying there's one. There's just a grouping of standardized forms for certain transactions. That's what that's referring to. Yep. So the two things that cannot be in the sales contract that are prohibited by rule, the no brokerage compensation discussion, no disclaimer of liability. Now, the other thing that you have to understand is we're going to talk about the standard form 2T. You're going to get tired of hearing me say it. I'm sure you already have because I just keep replaying it. But it is called the Offer to Purchase and Contract Standard Form 2T. And it is a standardized contract that is acceptable for residential resale. Residential resale. In and of itself, it is not acceptable for vacant land, and it is not acceptable for new construction. We have two other standardized sales contracts, one for vacant land. It's called the Offer to Purchase and Contract Vacant Lot and Land. And we have another one for new construction called the Offer to Purchase and Contract New Construction. So remember when I said the 2T is not the only form that exists. It is just one of the most common forms because the vast majority of transactions that we do are resale residential. And the reason why there's different forms for different types of transactions, folks, there is specific things that are an issue in one that may not be in another. For example, our standard Form 2T, which is good for residential resale, has a due diligence period. We're going to get into that in great detail tonight, but here's the bridge version. a period of time to investigate the property to make sure that you do want to move forward with the transaction. That's a due diligence period. Well, folks, if you're building a house from the ground up, a due diligence period doesn't make sense. You know why? Imagine you negotiated a 3-week due diligence period building a brand new house. You go out there on day 1, it's dirt. You go out there on week 2, it's dirt. You go out there on week 3, it's still dirt, maybe with some flags in it. Is that a good use of a due diligence period to look at dirt for 3 weeks? No. So it wouldn't be a legally adequate contract to use for a new construction that's being built from the ground up. So that's why we have different contracts for different types of transactions. So here's where we're going to get into the actual offer to purchasing contract. And I told you it's in a couple different places in your online program. And I'm just going to pull it up wherever I find it first. Oh, I already have it pulled up. And full disclosure, yet again, a lot of the things in your online program are the 2023 versions. That's not an accident. That's intentional because I told you there is some language that has been added into the 2024 versions for the NAR stuff, and none of the test questions have been rewritten. So I don't really want you to focus on that. You know, that'll get updated when and if they do update any questions or material. So let me give you a link in case any of you want to follow along with this. There you go. That should be the form. Now I'm going to explain what I consider to be the most important pieces of this, folks. It's 17 pages, but there's a lot of stuff they are not going to test you on, but there is equally as much that they are. So let me just start at the top, and then I'm going to get into the nitty-gritty, okay? It's called the offer to purchasing contract, and the reason why I keep saying standard form 2T is because if you look down here, it's got that in the corner. That kind of lets you know that it is, you know, in their library as Form 2T. Excuse me. And so, for valuable consideration, the receipt and legal sufficiency of which are hereby acknowledged, buyer offers to purchase and seller upon acceptance agrees to sell and convey the property on the terms and conditions of this offer to purchase and contract, and any addendum or modification made in accordance with its terms, together just referred to as the contract. Then we name the seller. And we want legal names, right? We need legally adequate names, no nicknames, what's on the deed. Buyer, same thing. What are their legal names? And then it talks about the property. The property shall include all the real estate described below, together with all appurtenances thereto, including the improvements located thereon, and the fixtures and personal property listed in paragraphs 2 and 3 below. Very similarly grouped to kind of the listing agreement when we're talking about the property itself. Now this little boxes right here were added in semi-recently, meaning last year's iteration. It says the property will or will not include a manufactured mobile home, and the property will or will not include an off-site or separate septic, boat slip, garage, parking space, or storage unit. I'm not really going to talk about the second one because they're not going to test you on that, but that first one, folks, why is that first one important? Will or will not include a manufactured mobile home?
Manufactured homes are personal property.
At least they start that way, right? Manufactured homes start as personal property and can be potentially converted to real property if certain criteria are met. And so we need to clearly name that regardless of whether it has or has not been converted, that it is part of the sale. And so there's no question about it transferring as well. Then we name the address of the property. And then, of course, we have some of those legal references too. Reference to recorded plat, also called the lot and block method. Reference to a recorded deed, a couple tax identifiers as well, just to make sure that there is no question about the property that we're exchanging, that we're purchasing, selling here. And here's where you get into the terms. And so I told you we're glorified blank fillers. Just on page 1, you can see all the blanks, right? We're filling in all the blanks on the property. And then, of course, we're filling in all the blanks on how we're going to purchase the property, or more specifically, how the buyer is going to purchase it. So they would come in here and they would say something like, I don't know why it's green, but we'll roll with it. 400,000. And then they would come in here and they'd say, okay, well, we're going to offer 1,000 in due diligence and 5,000 in earnest money. And then, of course, if we're not going to use any specific piece, best practice is to put in A. And so very commonly, we're not doing any additional earnest money. We're not doing assumptions or seller financing. I'm not going to say they don't exist, but, you know. And then, of course, the balance is what's left over. In other words, if we've already got $6,000 tied in that we're putting down in miscellaneous places between due diligence and earnest money, you know, what's the balance? What else is left to pay? That would be your, you know, $394, because you've already got $6,000. And so that's how we kind of fill this out. Now, do you need to know how to fill this out? No, I'm just kind of showing you. But let me focus on a couple of the big pieces here, folks. The first testable pieces, okay? When we negotiate, and I'll even put the numbers back up, due diligence fee made payable and delivered to seller on the effective date. There's big testable piece number 1. The due diligence fee is paid directly to the seller. So when you say you're giving somebody $1,000 in due diligence, you are writing a check, or cash, or official bank check, or wire transfer, electronic transfer, whatever we agree on, and you are handing it to the seller to deposit in their bank account that day. And when it says effective date, that means what? What's the effective date? Yeah, when it became a contract.
No, when you're submitting offer.
No, not submitting an offer. An offer is just an offer. It's not effective until it's a contract. So once they have signed it with no changes and communicated it back to the offeror or offeror's agent, right? That trigger for now we're under contract. So the day we get under contract, due diligence is due. And it goes directly to the seller. There is big piece number 1. Earnest money, if negotiated, made payable and delivered to escrow agent named in paragraph 1F within 5 days of the effective date of this contract. So earnest money goes to an escrow agent. That is a third party who is going to hold it in what's called an escrow account or a trust account. Could be a real estate brokerage firm, could be an attorney. But it is a third party that's holding that money. And it is due within 5 days of the effective date. You need to know that. What you got, Janet?
Is the earnest money for the seller or the buyer?
It's arguably for the seller if the buyer messes up. It's liquidated damages. That's what we talked about yesterday. It's a pre-negotiated amount that says, Mr. and Mrs. Seller, if I breach contract, here's what you're entitled to.
Okay.
Yeah, but if you don't breach, they don't get it. We're about to talk about that. So I'm going to go a little out of order here. I'm not going to read everything to you because I only want to focus on the most testable aspects and, of course, kind of build up to some of the more difficult pieces here. Beverly says, due diligence funds are non-refundable. Let me go ahead and make something clear here. As long as the buyer closes on the property, they get to keep both the due diligence and the earnest money. It's theirs. So as long as they close on the property, in this fictitious example where I just said they had $6,000 tied up, that's $6,000 that goes towards their purchase. It's theirs. Due diligence is non-refundable if they terminate the contract during their due diligence period. They've spent that money to have the right to terminate. And then earnest money they would only lose if they breached the contract, which means they terminate after the due diligence period. Yeah. What you got, Beverly? Oh, you're muted. muted, 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 muted. There you go.
If the buyer terminates prior to the due diligence or inspection period, the EMD is refundable?
Yes.
Okay.
Yep. Yep. Yeah, and hang tight, folks. I'm about to explain this all in great, great detail. Because this is arguably going to be some of the most testable pieces of this contract. So I'm going to focus on this piece right here first, the earnest money deposit. Even though due diligence is what we talk about first on the contract, this is kind of going out of order, but it's okay. The initial earnest money deposit, the additional earnest money deposit, and any other earnest monies paid or required to be paid in connection with this transaction, collectively just called the earnest money deposit, shall be deposited promptly and held in escrow by escrow agent. The earnest money deposit will be credited to the buyer at closing or dispersed as required in this contract. So, held in escrow, but the buyer gets it back at closing as long as they go to closing. Here's where you name who the escrow agent is. As I said, it's just a third party who's going to hold the money. Could be a brokerage firm, could be an attorney. Doesn't really matter who holds it, but somebody's going to hold that money. It's kind of like an unbiased third party, if you will. Now, here's the thing, folks. Before I read anything else to you, let me just go ahead and explain this in a nutshell. And I'll let you ask some questions, then I'll explain the more testable pieces here. When we submit an offer, and let's just use the numbers that I just kind of went with, and I'll just kind of write them right here. Why does that look like that? There we go. If we said that there was, looks crazy, but whatever, $1,000 in due diligence money, and $5,000 in earnest money. I told you due diligence money is due on the effective date to the seller directly. Earnest money is due within 5 days of the effective date going to this escrow agent. But what we're going to show you on the contract in a second is the due diligence money is typically accompanied with what we would call a due diligence date. So we're going to put a date on here. And so let me just use an example here. You know, don't worry about how long it's supposed to be. That's not something that you need to know. There is no standard, if you will. I would say that on average, we would probably do about 3 weeks if we could get it. Give enough time for inspections, re-inspections, things of that nature. And so let's just say, I don't know, December 20th. And so let me try to explain what happens here. I submit this offer on behalf of my buyer clients. The seller accepts it. I've got to give the seller $1,000 from my buyer clients the day it turns into a contract. I've got to deposit $5,000 from my buyer clients into the escrow agent's trust account within 5 days. And so what the due diligence money and the due diligence period really is, folks, is the biggest way that we can potentially combat the doctrine of caveat emptor. What is the doctrine of caveat emptor? Remind me. Say it again.
Is it buyer beware?
There you go. Let the buyer beware. Remember, North Carolina, the sellers don't have to disclose anything. And so that means we really sometimes have no idea what we're getting into on a house when we go under contract on it. And the due diligence period helps us with that because now we've got a contract, but we've got this period of time that we have negotiated where we are allowed to come into the house and do inspections. So we'll get general home inspections, we'll get pest inspections, well inspections, structural engineers, whoever and whatever we think is necessary for us to make good decisions on this home. And so understand, though, that you've paid money called the due diligence fee to have this period of time. And so let's say that you get under contract today and you have until December 20th and you get a home inspection, a pest inspection, a well inspection. And let's say that the home inspection reveals that there is $30,000 worth of foundation issues that need to be worked through. And you just don't want to deal with that as a buyer. You can terminate the contract in your due diligence period The way that the language is written, you can terminate for any reason or no reason, folks. You don't have to have a reason. Now, in this instance, I'm giving you a reason. You don't have to have one. You've purchased the right to terminate for any reason or no reason during this due diligence period. But if you terminate, you do not get your $1,000 back. The seller gets to keep it. But understand the benefit. Losing $1,000 is way better than being on the hook for $30,000 worth of foundation issues. And so the due diligence fee is paid to the seller for you having the right to terminate for any reason or no reason. But they only get to keep that money if you don't buy the house. If you buy the house, they got to give it back to you. You get a credit at closing from the seller. Right? We take it back from them. Due diligence on the closing disclosure is a seller debit buyer credit. We take it back from the seller and give it to the buyer as long as you go to closing. But if you terminate during your due diligence period, you've lost that money. The seller gets to keep it because they gave you the right to inspect. You purchased it. So no matter what, if you terminate during due diligence, you don't get that money back. What you got, Beverly?
Why wouldn't you just not pay the due diligence and just pay EMD? Because the EMD is refundable if you go under contract. You know what I mean?
Yeah. No. So there's two parties to the transaction. There's the seller and the buyer. And to a buyer, that sounds great. Does that sound great to you as a seller? Take your house off the market for 3 weeks for somebody to rip it apart and figure everything out about it, and then they can terminate, and you have no money?
No, but we got away with a lot of that. Like, I don't remember ever putting down deeds.
When was the last time you bought a house?
Huh?
When was the last time you bought a house?
That would have been 2010.
I think, if I'm to be honest, due diligence money came about in like 2011, 2012, so it probably wasn't a thing back then. And that's the reason why it came about, Beverly, because buyers would get under contract on 3 different houses because they had no skin in the game. They would take a look at all of them, figure out which one they liked the best, terminate on the other 2. Now the sellers had been off the market for 2 weeks. Then they had to go back on the market, and they lost all this time. So this was designed so the buyers had some skin in the game so they couldn't screw over the sellers.
That explains a lot, because at one point in time we were under contract. We had like 3 offers in on 3 different houses. This was in Raleigh. We didn't buy, but at that time that's where we were looking. So that explains a lot. Yeah,
there you go. That happened too much and sellers were getting screwed. So this was designed to be fair to both the buyer and seller. So the buyers had some skin in the game, so they couldn't just screw over the sellers. Yeah. So if you terminate, once again, folks, when I say terminate for any reason or no reason, I mean any reason or no reason. If you wake up one morning and you say, I've decided I'm just going to keep renting, you can terminate. You're going to lose $1,000, but you can do it. If you wake up one morning and you go into a state of psychosis and you think a squirrel is talking to you and the squirrel says, don't buy the house, you can terminate. Doesn't matter. Any reason or no reason. During your due diligence period. Now, here's the thing, folks. Earnest money, we said, is going to be held by a third party, the escrow agent. And as long as you terminate within your due diligence period, as a buyer, you are entitled to get the earnest money deposit back. That $5,000 gets refunded to you. But if you terminate after your due diligence date has ended, that is now considered a breach of contract as the buyer. And I told you, earnest money is liquidated damages that the seller is entitled to if the buyer breaches. So if your due diligence date is 12/20 and you terminate after your due diligence date, and it's going to get a little more technical than that in just a second, then now you have lost both your $1,000 due diligence money and your $5,000 in earnest money. The seller is now entitled to keep it. Everybody with me? So I'm going to make sure we're all on the same page here, folks. If we terminate during our due diligence period as a buyer, what monies are we entitled to get back? There you go. Earnest money deposit only. If we terminate after our due diligence period as a buyer, what monies are we entitled to get back? Nothing. And I cannot stress how many different questions you will get on the test about this concept. A lot. And it will give you details. They're under contract on this date. Their due diligence period is this date. They terminated 2 days after their due diligence period, which is the following is true. And it'll say they'll get this back, but not this. They'll get both back. They'll get neither back. They can't terminate. Like, those are the kinds of questions you're going to get. And you've got to know what you're entitled to get back, when, if, all that jazz. Now, what you got, Sinful?
A question. So, after DD period, during the home inspection, okay, some huge damage in the house, which it will cost to fix 50,000. So, then seller, they're not ready or they're not agreed to, fix the issue. So, in this situation, I don't want to buy a house. Okay. If in the situation, so the means buyer, they will get a DD fee or not?
Does the buyer get the due diligence money back?
Yeah.
No.
Because it's not my buyer issue, right? Because
No, but that's why you paid that due diligence fee, to have the right to find that out.
oh, okay.
And so once again, Synthel, I mean, losing $1,000 sucks, but it's better than losing $50,000, right?
Yeah.
So, I mean, understand that I'm just giving examples, folks. I mean, it's whatever we can negotiate. I mean, if it's a slower market and there's a lot of competition, and I mean, back in the day, I've negotiated due diligence fees as low as $200 before. I've also had sales where I've gotten $50,000 in due diligence money. It really depends on the market because of the way that people use it. But yeah, you don't get it back. Brad says, couldn't you renegotiate the contract? Remember, contracts are voluntary. So sure, if buyer and seller are both willing to renegotiate, could you? Yeah. But if the seller says, I'm not making repairs, your only thing is to walk away and get your earnest money back and just lose your due diligence money. Because seller didn't have to tell you anything. And if you find it out, and it is what it is, you can terminate. Sergio, what you got?
So I remember when recently a guy was selling the house. He kept putting the ad, and what he was doing is putting the ad in and knowing that the property had a lot of bad damage to it just to keep getting the due diligence money. So he was using that as a scam, and he came out like almost $100,000 for that house.
Was he using
Never sold it.
an agent?
No, he was. I think he was selling it on his own.
I mean, arguably,
I think it was in the Raleigh Durham area, so he was up here. I think it was Sanford that he did it.
yeah, I didn't hear about that, but I mean, those kinds of things have happened, and of course, this is why you'd want to use a real estate professional, because as a professional, I'd ask questions, why did it fall through? When it was, how many times was it under contract? And if he lied, I mean, that's fraud. So, I mean, they're not allowed to lie. They just don't have to disclose, right? And so, yeah, got to be careful with that kind of stuff. Gerald says, is there any way for the buyer to get their due diligence back if the seller breaches, for example? Yes. There is 4 very specific times that the buyer could get their due diligence back. But we're not there yet. But yes, there are. So let me explain something else before we get into a little more of the nitty-gritty things, folks. I already told you that this contract is exceptionally clear on what happens to the due diligence and the earnest money under most circumstances. However, an extremely testable aspect of the earnest money deposit is this. This note right here. So it says, in the event of a dispute between seller and buyer over the disposition of the earnest money deposit held in escrow, a licensed real estate broker is required by state law. An escrow agent, if not a broker, agrees to retain the earnest money deposit in the escrow agent's trust or escrow account until escrow agent has obtained a written release from the parties consenting to its disposition, or until disbursement is ordered by a court of competent jurisdiction. Alternatively, if a broker or an attorney licensed to practice law in North Carolina is holding the earnest money deposit, the broker or attorney may deposit the disputed monies with the appropriate clerk of court in accordance with General Statute 93-12. Now, let me explain this. Folks, I'm going to say it again, okay? If I am have a buyer client who is under contract on a property and they elect to terminate during their due diligence period, what money is the buyer entitled to get back? Earnest money, yes. So here's what you have to understand about this. Even though we know without a doubt that they are entitled to get it back, if the seller was to say something like, don't you dare give him that money, the escrow agent has to keep holding it. We are not allowed to disperse it, even though we legally know who it's supposed to go to. Very, very testable. We would continue to hold it until everybody signed a written release saying, oh, okay, give it to the buyer. If we don't get that, then we can't give it back to even the person we know is supposed to get it. And that means that they would ultimately end up probably taking each other to small claims court. It's going to be a very easy case for the non-problem party to win because this contract is very clear on who's supposed to get it back. But I'm telling you, it's extremely testable that if there's any dispute between the disposition, no matter who's entitled to it, we can't give it back. So same thing the other way. Let's say the buyer terminates after the due diligence period. Who's supposed to get the earnest money? The seller. But if the buyer says, don't you dare give him my earnest money, yet again, the attorney, whoever the escrow agent is, would have to keep holding it, even though we know who it's supposed to go to. Now, the last little provision in here states that if we get tired of holding it, because the only way we can disperse it is if they have a signed agreement between them, or if they take each other to court and Judge Judy tells us who to give it to, or if we don't want to wait for either of those to happen, we could deposit it with the clerk of court in the county that which the property is located in, which is basically where we just send them a notification. We're not holding it anymore. The clerk of court is holding it. Go fight with them. Those are all acceptable. Let me scroll back and answer some of these questions that y'all asked. Lisette said, is there a specific time range to be under DD, or does the buyer decide the date? Do you mean like the due diligence period? Is that what you mean? Yeah, no, there's no, like I said, there is no specific time frame. It's whatever we negotiate. I told you in the real world due diligence periods, we like to see about 3 weeks as a buyer's agent. But sometimes it's less, sometimes it's more, depending on the property. Also, somebody asked something earlier. I think it was Jana asked about it being a deposit. Yeah, I mean, notice the names. We call the due diligence fee a fee, and we call the earnest money deposit a deposit. But no matter which way you slice it, as long as the buyer goes to closing, the buyer gets both back, right? It stays their money. It would only be if certain things transpire that they would get neither back. Is it more typical for earnest money to be held by an attorney, buyers, or sellers? An attorney. Most commonly is the attorney handling the closing. Bree asked, would this be a breach? Of course, with like the not willing to sign the contract. Arguably, if somebody's getting the earnest money, if the seller's entitled to the earnest money, the buyer's already breached, and then of course, it wouldn't necessarily be a breach of contract. That would just be, it does clearly state that if we kind of go into litigation with each other, that the losing party has to pay the winning party's court costs. It does say that later in here. But like I said, big takeaway though, even though I'm teaching you, it's going to be very testable, who gets it, when, where, what, how, why. You've got to understand that if there's a dispute, we have to keep holding it until they sign a written release between them, until Judge Judy tells us who to give it to, or until, we get tired of holding it and we can deposit it with the clerk of court.